Recording has stopped. Recording has started.
The Court of Appeals, State of California, First Appellate District, Division 3 is now in session. The Honorable Allison M. Tucker presiding.
Good morning, everyone, and welcome to Remote Arguments of Division 3.
Good morning, Your Honor.
Good morning. With me on the bench this morning are Justice Fujisaki and Justice Rodriguez. We have 4 matters on the calendar, and I'm going to start by calling the first, Seth Samuels versus Hamrick and Evans. This is case A158688 and A158878. May I have appearances, please?
Robin Meadow representing the appellants.
Frank Summers representing the Samuels parties, plaintiffs below, and respondents.
Thank you. Mr. Meadow, would you like to reserve some of your 15 minutes for rebuttal?
I would, Your Honor. 5 minutes, please.
All right. I will try to help you keep track of time.
Thank you.
Go ahead.
All right. Your Honors, I'd like to focus on one discrete issue in the appeal, and that is whether interest can be awarded under Civil Code 3287A. The tentative opinion, I believe, has a misconception about our arguments on the issue and how that issue should be decided. At page 29, the tentative... Sorry? At page 29, the tentative says the defendants reasoned that because there was conflicting evidence on issues pertaining to their liability, the amount of money they owed the plaintiffs could not have been made certain until after liability was established. And the opinion then goes on to explain how the judgment could have been calculated with certainty, and that collectibility is an issue of liability. Where the tentative opinion, I think, goes wrong is that collectibility plays 2 distinct roles in this case. Certainly collectibility is a liability issue. The plaintiffs had to prove that the judgment, the underlying judgment, was collectible to at least some extent in order to show causation of damages. But that number could have been anything from $1 all the way up to the full amount of the judgment of $2.2 million, including the post-judgment interest that accrued through 2008. That's the second element of collectibility. It plays a role in the determination of damages. And the extent to which the judgment was collectible was uncertain until the trial court actually found that it was fully collectible. Going into trial, there were plenty of disputes about the extent to which the judgment was collectible. We challenged, I think, virtually all of the evidence on the subject, and the case could have come out differently. Certainly, a judgment that said only $1.5 million, for example, could have been collected, would also have been supported by substantial evidence, as this court has found that full collectibility was. So going into trial, that question was still an open question. The amount was still uncertain. And that's what the courts mean when they talk about an uncertainty of damages. Assuming liability, assuming even $1 could have been collected, the defendants would be liable, but the amount is uncertain. This is the argument we made at page 50 of our opening brief. We came back to that theme, page 34 of our reply brief. We argued at length until the court decided full collectibility, the issue was open. That means that if there was no waiver of prejudgment interest, which is a distinct issue, interest can be awarded only under Civil Code 3288. Now, why does this matter? Under 3287A, interest is unquestionably mandatory. If properly requested, the trial court must award interest going back to the mid-2008, which is when the amount should have been collected. 3288 provides the trial court with discretion. Its discretion whether to award interest, and I believe fairly read its discretion as to how much interest to award, how far back to award interest, whether there are any periods during which interest should not be awarded. It's 7% interest under either scenario, but under one scenario there is at least a possible outcome of no interest at all. Now, the trial court here did not exercise its discretion because it didn't believe it had any. The plaintiffs persuaded the trial court that the way to calculate the judgment was pure damages, interest accruing on the underlying mid-2008 judgment, interest accruing from 2005 when the judgment was entered all the way through the date of entry of judgment here, and that was damages, just classic damages, no interest. Every time we raised the argument that it had to be pre-judgment interest calculated at a lower rate, and this was in our objections to the statement of decision, in the new trial motion, in the briefing on the new trial motion, and of course in this appeal, the plaintiff's argument was just, well, that's just wrong. The trial court was never presented with an opportunity to exercise any discretion, so it didn't exercise discretion. And on remand, if the court confirms its tentative opinion that collectability for liability purposes was proven, the remand should direct the trial court first to decide whether interest should be awarded at all under 3288, and if so, how much. The tentative opinion says that we provided no calculations with respect to a 7% calculation. We actually did. It's on page 34 of our reply brief if the court wants to see how those numbers play out. And I'd like to reserve the rest of my time if I may.
Okay, thank you very much. Mr. Summers.
You're on mute.
They told me not to touch my mute commands because the deputy would do it all, so thank you for catching that.
All right.
If I may, I'd like to start with something in the nature of an apology, which is I'm a relative newbie compared to Mr. Meadow in the fields of appellate swashbuckling. So if I commit any procedural errors, please consider them inadvertent rather than deliberate. It's interesting. I have sections in my notes that say appellant's arguments. Do we need to? And I also am going to focus on the interest. But I have one question. Does the court in its tentative opinion called out, I think, 4 different instances where they felt that the appellants had misstated the record below, and it appears to me that you only did that in service of finding the facts necessary to support the opinion, as opposed to because it's an independently considerable matter. And the reason I raise this point is there are additional items of that type of conduct, but if there's no portion of the process here, if in finding substantial evidence supporting the verdict, the good faith, bad faith, or conduct of the appellant's counsel plays no role beyond what you've already said, then I'll leave it. I don't intend to waste time with something that's not pertinent to your decision-making process. So if I might ask that question in a rather long-winded fashion.
So one of the rules is that we get to ask the questions. I'm not sure we
Fair
have
enough.
a good answer for you other than what we put in the tender at this point.
Then let me dive into the interest. As I understand the court's analysis, the conclusion is since collectability is a necessary component of liability, and since Judge Robertson found that the earliest date that malpractice occurred that justified a finding was 2008, and necessarily found collectability as of that point in time, the assumption that the court seems to make is the judgment would have been satisfied at that time. And you cite me to code sections 685.010 and .030, as well as the Bell case. But I suggest that those sections militate for a different solution, which is they hold out the idea, they mandate the idea that until a judgment is satisfied, it necessarily bears post-judgment interest at a rate of 10%. And you go on to say in the next sentence, or several sentences later, that
That was my mistake, and I apologize for it.
is that the end of Mr. Meadows' time? I'm sorry, I lost. Oh, that it obviously wasn't satisfied, and therefore we dropped down to the malpractice 7% interest rate from that point forward. And I suggest that logically and equitably, that isn't the proper result, because unlike cases where the malpractice consists of the failure to secure a judgment and the argument that if you had secured a judgment in the court at that time, post-judgment interest on that malpractice avoided judgment is 10%. We have a different situation here. We have a situation where the judgment that was accruing, admittedly, post-judgment interest at 10%, had been entered by the arbitrators and confirmed by the court. And it's therefore in the nature of a guaranteed investment, a T-bill carrying 10%. I mean, if you find any of those lying around, please send me one. But hypothetically, it's an investment that is for a sum certain at a defined interest rate. And nothing about the malpractice makes that uncertain. And therefore, given that the judgment was not in fact satisfied in 2008, even though had Green acted the way he should have, there would be no, it would have been paid off. It seems to me that you're penalizing the respondents to the tune of 3%, which when you do the math comes up to about $750,000 over the course of time that we're talking about.
Mr. Summers?
Yes, sir.
Can you respond to Mr. Meadows' point that the amount actually was not certain until we had some sense of collectability, which is to say that notwithstanding whatever the measure of damages was, if the defendants here had not been able to pay, if they had been insolvent, then your damages would have been whatever they had been able to pay, which could have been nothing. And therefore, until collectability had been resolved, that uncertainty would also impact the availability of interest.
The argument, I think, falls to the line of authority that says, look, if what we're litigating is in fact liability, then and if the number can be calculated, that there is no uncertainty. And I admire Mr. Meadow for trying to put a bone in my throat, but the issue here is Green had, as Judge Robertson went through in exhaustive detail, records showing it was collectible at the time. The court's review of that evidence, both Robertson and then your review as a predicate for the tentative opinion, doesn't render the amount uncertain. I suggest Mr. Meadows' attempt to split collectability into two different hares or two different horses, run one in the liability sweepstakes and one in the interest sweepstakes, is adroit but unwarranted. Now, I have to admit, I haven't found any cases that bear on the exact fact statement here, i.e. an asset that's generating a fixed rate of return as of the date of the malpractice, independent of the malpractice. At the same time, I haven't found any cases that say, as a matter of public policy, we're reaching the conclusion that notwithstanding whatever the asset was, piece of property, whatever, a claim, we find that the nature of a malpractice action means that you have to take 7%. So I think both sides are arguing from law that reaches into this area but doesn't dictate a result. Let me also point out that the law firm continued to represent the Samuels until, early 2013, and continued to tell them over and over again, starting in 2008, that don't worry, even though we're withdrawing the 2008 action, we will still be able to go after the individuals. And they repeated that in bankruptcy and failed to do so. So the idea that the point at which, in effect, the last clear chance that they had to fix this was 2012. And so there is an intermediate ground, if you will, saying, look, the post-judgment interest, if we conclude that nevertheless, nice try, Mr. Summers, but we're going to go with the end of post-judgment interest and the institution of pre-judgment 7% interest. I would suggest that you can point out to Judge Robertson that there is an ability to push that date back to 2012. But I suggest that's a split the baby solution. That the proper solution is to say, look, they had an asset drawing 10%. You guys messed it up, and it's never been paid off. And the idea that because of your malpractice, you get a $750,000 haircut seems to fly in the face of both fairness and what appears to be the law. Because remember, Civil Code Section 3333 says all damages proximately caused are recoverable for non-contractual violation. And that taken with 685 would seem to say that the law has expressed a decided opinion in favor of the wronged plaintiff recovering the full measure of damages. And I haven't heard any articulation certainly not in the brief. The idea that Judge Robertson didn't think he had the ability to exercise discretion appears nowhere in the post-trial briefing. They argue that interest is inappropriate. They argue this, that, and the other. But the idea that they can raise this concept here would seem to be, even to me as a newbie, past the boundary line. It's a foot fault at least. So anyway, does that respond to your question, or do you feel like I tried to duck it?
It does. It's just that here, what the tentative talks about is that there's a difference between picking the legal theory and disputed facts. And here we had a dispute among experts as to whether or not this in fact was collectible, and Judge Robertson found one expert credible and the other not. But had Judge Robertson found that the other expert had been credible and that there had been no collectability, that would have impacted obviously not only damages but also interest.
We would have lost. But I suggest that the record is slightly different. What we were arguing about, what appellants did from day one, was they challenged the admissibility of the documents and the testimony of the financial experts. And what they said was, look, these documents don't mean what they say. And it was an evidentiary argument throughout. The idea that their expert, for example, didn't come in and say, okay, the Jiangmen China project or the Tender Avenue, the Pearl Gateway project weren't worth $15 million or $8 million or whatever they were. They were worth $1.5 million or $200,000. If that had been the nature of the evidence, then perhaps they could argue, at least with a fig leaf, that there was uncertainty as to the collectible amount. But what they did was they bet the entire farm on evidentiary objections. And then in the post-trial briefing, they proceeded to say, for example, that the accountant hadn't validated the financials, hadn't authenticated the financials, and therefore the court shouldn't consider them. And as I think you pointed out, I'm not you, but the panel pointed out, Judge Robertson said, well, turn the page in the deposition, boys, and right the next page he authenticates them up one side and down the other. And so I'm a little frustrated, not at you, but at the idea that we're arguing about false premises, that it is not uncertainty as to the dollar amount, either of the judgment that's ticking away at 10%, or about the numbers in the financials. Their argument was purely evidentiary, and I suggest it doesn't present the same kind of dilemma that you're concerned about, right? That if we had two different real estate experts arguing about the process, or somebody had come in and said, look, I'm an expert in Chinese law, there's no way in hell they would have been able to attach the Jiangmen project. That's different. Then the dollar amount of available capital would have been an issue, but that was never the way it was set up. I believe I can say it again differently, but that's pretty much the gist of my argument. If I can summarize, just the 10% extrinsic judgment, post-judgment interest on the underlying construction defect is an asset that they should not be penalized because they hired incompetent counsel from recovering. The finding, but let me put it this way. Hamrick and Green said repeatedly, we're going to go after these guys. it is obvious to you, as it is to me and Mr. Meadow, that Hamrick would have been suing these individuals for the full 10% amount. The idea that there's a different measure of recovery that creates uncertainty is just wrong. It's preposterous, and I suggest you shouldn't entertain it here. I'm eminently happy with the tentative opinion, with the sole exception of that $750,000. But I hope I've addressed that issue in a way that persuades you to change the ruling in that regard, and in no other.
All right. Thank you, Mr. Summers. Mr. Meadow, would you like a rebuttal?
Yes, Your Honor, thank you.
Mr. Meadow,
yes.
at the outset, can you respond to Mr. Summers' argument that here your clients did not actually dispute the facts of collectability? That really what the argument was issues of admissibility, the sufficiency of the evidence that was presented, but that your expert, Ms. Sitko, didn't testify about collectability, but testified about the alter ego theory. And so really there was no dispute about fact about collectability, is whether or not this evidence was sufficient or not.
I strongly disagree, Your Honor, and the reason is that, although it's true, we did seek to exclude most, if not all, of the evidence, and had we done that, there would have been, well, we would have prevailed. There would have been a defense judgment. But when you challenge evidence, and by the way, it went beyond just challenging the validity, the admissibility, the credibility of the evidence. We also argued the trial court found explicitly that the defendants were expert at concealing their assets. You'll see that at pages 1379 and 1401 of the appendix. Relentless efforts to divert and conceal assets. The defendants' belief, the alter ego defendants' belief they could outlast the plaintiffs. The point is, throughout this case, it's not an on-off switch, Your Honor. When you challenge evidence, you're challenging its credibility. When we challenge its sufficiency, we're challenging its credibility. The trial court was not required to accept any of the evidence that the plaintiffs offered, even assuming that it's admitted. Otherwise, the statement is that the receipt of evidence of assets or net worth automatically translates into a directive to the trial court that it must find that evidence valid as a matter of law. That's not how fact-finding worked. And the fact that they did offer a large number of assets, if the trial court had rejected any substantial amount of that, the lawsuit would have looked very different. I can certainly talk about some of the areas where I think it should have, but for these purposes, this was a litigated issue. The trial court spent pages and pages of the statement of decision talking about issues of collectability, and collectability doesn't mean 0 or 2.2 million. $1, as I said before, $1 would suffice to establish liability. The next step is how much. Now, the trial court found as a factual matter that there were sufficient assets to have collected the whole judgment. It didn't have to be that way. And the fact that it didn't have to be that way, that the finding was not compelled as a matter of law, precludes a finding that there was any certainty as to the collectability, as to the amount of collectability of the judgment. As to the concept that the plaintiffs are somehow penalized by a 7% interest rate, as in the trial court and in their brief, we're mixing apples and oranges. The judgment was always collectible at 10% against the original defendants, the judgment debtors. The renewable judgment, the judgment was properly renewed against the original judgment debtors. But what Green and his firm did wrong culminated in the failure to collect the judgment when they should have in 2008. And that's the benchmark every legal malpractice case looks at. What could have been recovered, what should have been recovered. The entire loss was sustained at that moment. The fact that there was continued representation afterwards is really irrelevant, and here's why. The continuing representation provided the lawyer defendants with the opportunity to mitigate the damages. If they had ended up collecting the entire underlying judgment with all of the 10%, there might never have been a malpractice case at all. Their malpractice, if it hurt anyone at all, their post-2008 malpractice hurt them. It didn't hurt anyone else, because in contemplation of a cause of action for legal malpractice, everything was over and done in 2008. And there was no certainty of the amount until 2008. So what we have is a situation in which, if there is prejudgment interest at all, it begins no earlier than 2008. It must be 7%. And again, since 3287 doesn't apply, this is a matter entirely within the discretion of the trial court to determine. Thank you.
Thank you, Mr. Meadow. Thank you to both counsel for your enlightening arguments this morning. The matter will be submitted. And with that, if we can have a change in the counsel available, I will call line 2, the matter of Spahn versus Richards, case A159495. Looks like we have respondents counsel with us. Let's see if we can get appellants counsel as well. There we go. May I have appearances, please?
Yes, Mark Stempert on behalf of the plaintiffs and appellants in this case.
Good morning, Justices. Nicole Campbell, Katzoff and Riggs for